Good morning, everyone. Thank you all for joining today's webinar on fundraising in Europe without a passport. I'm Fabian Euhus, an associated partner in the fund formation practice of Schnittger Norman Partners, and will be hosting this webinar today. I've been advising German sponsors of private equity, venture capital, and fund of funds on their fund structures and international fundraising for more than 10 years. In our webinar, we would like to discuss the options for the marketing by managers of private equity and venture capital funds, most of which, at least in Germany, are not fully regulated, but operate as so-called sub-threshold managers. To span the bridge from theory to practice, we will give an impression what sub-threshold fundraising for an EU manager looks like in 3 very interesting fundraising target countries: France, the United Kingdom, and Switzerland. We are honored to be joined today by excellent colleagues from renowned law firms in those countries. Christophe Sevennec from Chammas Marcheteau in Paris specializes on fund structuring and formation of asset management companies. He advises clients on all legal aspects of structuring, creation, and marketing of AIFs and UCITS in numerous asset classes. Chris also advises clients on regulatory issues, in particular the formation of investment management companies and approvals from the French financial markets regulator. The UK perspective is brought to you by Christopher Dearie of MJ Hudson, London. Chris is the head of MJ Hudson's regulatory practice. He focuses on financial services law and regulation. Chris advises asset managers, banks, and domestic and international investment funds on a broad range of financial services regulatory issues. He has extensive experience in regulatory matters relating to the structuring, formation, and marketing of onshore and offshore funds and other investment vehicles. From the UK on its way out of the European Union to a country that is a so-called third country from the EU perspective. The marketing regime in Switzerland will be brought to you by Dominik Oberholzer from the Zurich office of Kellerhals Carrard. Together with his team, he specializes in banking and finance with a special focus on the asset management industry. Dominik is a regular speaker at the Europa Institute of the University of Zurich, the Fund Academy in Zurich, and the University of Liechtenstein. At the beginning, my dear colleague Lennart Lorenz will give us an overview of the regulatory situation of German managers and highlight the different possibilities of marketing with and without a passport. Lennart advises German and foreign sponsors, managers, and investors in the field of alternative investments on all matters of regulatory law. Further, he advises financial markets players on MiFID regulatory issues. Last but not least, Lennart is also a member of SMP's crypto team. We are very happy to receive your questions and comments over the form on the website. We will pick them up whenever possible or follow up after the webinar. And now, over to you, Lennart.
All right, thank you, Fabian. So yeah, thank you for the introduction, Fabian. My name is Lennart. I have the privilege of giving a brief overview on the regulatory landscape, and maybe just go one slide ahead, Fabian. I have opted, oh, that's back. So I'm the bald guy. So once we get there, as you can see, I've opted to include what I like to call the regulatory ladder. I think it gives a good overview of the possibilities fund managers have when they consider setting up a fund. Basically, it's a very small ladder because in my perception, it only consists of 3 steps. And the reason why it's a ladder, so it's basically going upwards. We have the sub-threshold managers, which are sometimes also called, small managers or only registered managers. Then we have the EuVECA managers in the middle, and then the fully licensed AIFMD compliant managers on top. Each each step basically has its advantages and disadvantages. It always depends on what the fund managers or the fund sponsors are looking for. So if we start from the bottom, the sub-threshold manager, it's a very limited regime with regards to prudential oversight. The steps of obtaining the license to become a sub-threshold manager with BaFin, the German regulatory authority, are pretty simple. The amount of documents we need to submit are fairly small. There is no, BaFin does not approve or does not check the managers themselves. So there's no fit and proper test. They don't assess the quality of the managers, so to speak. But there are some requirements which need to be met by the manager themselves. There are basically more, but it breaks down to two requirements, you could say. One is the sub-threshold managers obviously need to be below a threshold, and there are two of them, depending on how the funds are set up. So if the funds use leverage or are open-ended, we have a 100 million threshold, which is not that common in the PEVC area. So what we typically look at is the 500 million threshold, and that applies if the fund is, or if no leverage is employed, the assets under management are below 500 million euros, and it's a closed-ended fund, so there are no redemption rights within the first 5 years. The other criteria is that the manager may only manage so-called Spezial or special AIFs. Those are AIFs where only professional and semi-professional investors can invest in, meaning professional investors under MiFID, so basically more or less institutional investors and semi-professional investors. Again, more or less what it breaks down to is sort of sophisticated investors who are willing to commit at least 200,000 euros and make this sort of assessment. But essentially the manager has to sign off on the assessment, meaning technically it's an assessment by the manager saying that the person investing is understands the risks that are associated with the investment and has the experience and knowledge to make that own assessment. That's basically the scope, I would say, of the requirements. Then you have the EuVECA manager that's sort of like in between on the ladder between the fully licensed and the sub-threshold. It's in between because the regulatory landscape of obtaining a license are more complex, I would say. There's a test, so to speak, on the managers. So we need to submit information on the managers. They need to be sort of like a fit and proper test, if that's a common used term. CVs need to be submitted, and then there are also from the funds on the fund side, there are also more requirements. So what can the fund invest in? It needs to have a certain scope, basically in line with the scope that the European legislator wanted to have. There are also some other requirements that typically come up in the registration process. It used to be one of the main points, now still a talking point, is the own funds requirement. So the manager needs to have a specific amount of own funds available, and that needs to be proven to BaFin. The amount is equal to at least 1/8 of the annual fixed overhead of the preceding year, and if it's a new fund, it's based on the planned annual. That can be difficult at times. If it's a new company, it's fairly easy to keep it low. But if it's an existing manager that let's say used to be a small sub-threshold manager, it can definitely be quite a substantial amount. that need to be kept sort of on as no working capital on a different bank account. And then there's some organizational and transparency requirements, which we also need to provide. Fabian, if you could. And then we have the fully licensed, obviously, which we will not go into now. That is just the full AIFMD compliant. Typically, it's not something that VC managers look for, and also in that case, not PE managers. It's fairly uncommon for these types, because in theory, the subthreshold should be sufficient with a 500 million cap, at least for most of our clients. If you could skip one page. So just to give you a graphical illustration of how things have evolved since the AIFMD and then the German trend implementation in the KAGB, how they have evolved over the last 5 years. This is something that BaFin in a recent podium discussion published or presented the number of applications and actually filings in Germany. So in the beginning, we had very little subthresholds in 2013, but in the last 5 years, this has really taken up, and we see this in practice. Reason being, as I said, it's fairly simple to obtain. It's fairly cheap to obtain, and there's almost no regulatory oversight. There's just an annual report that needs to be filed. Then we have the EuVECAs. We definitely see an uptake in those, and in particular since March, since it was changed and amended the regulation. We are currently, according to BaFin, at 26 EuVECA managers in Germany, just one behind Luxembourg, and we are definitely working on surpassing Luxembourg in that regard. And then we have the fully licensed, so there's an increase, but it's not that substantial in comparison to the others. That is just as an overview. So as I said in the beginning, it really depends. The type of manager depends on a lot of aspects. But if we take the problem with choosing a manager is always there's an upside, but they're technically, or in theory and also in practice, there usually is also a downside. So while the subthreshold manager is easy to obtain the license, and it's easy to uphold because there's not much regulatory oversight, the downside is marketing. And that is because there is no, as we will see when the next two objects pop up, there is no marketing passport for subthreshold managers. There's an exemption or an option in the AIFMD, which allows countries to establish a sort of like a simplified regime for marketing, but it's not per se a marketing passport, which means that subthreshold managers, they need to look at every country individually, which they intend to market to. And there are countries where active marketing is not possible. On the other hand, so in the middle, we have the EuVECA regime that grants the EuVECA manager a passport to market all of its funds in EU 28 until Brexit, and then EU 27. Without basically any hassle. Since the amendment also, there is no charge, no fee being charged by the member states. It's a fairly simple process. And I forgot to mention this, but also one of the upsides of EuVECA is obviously because that the investor is not only professional investors, but also EuVECA semi-professional investors, meaning the subscription amount is lower to 100,000. So that is also definitely an upside of the EuVECA and also the passport. And then the last point is to mention briefly the fully licensed managers. The passport that the AIFMD foresees is actually only limited to professional investors, meaning that countries are or have to open it, have to grant the passport, but only to professionals. there are exemptions, Germany being one of them, which also allow marketing to semi-professional investors if the requirements are met. Denmark is another one that allows it. Sweden and Finland also allow for it, but this is something that is decided on a member state basis. One might think that you can simply, if you have the fully licensed manager, that you can passport all of your funds from retail to professional, but that is actually not the case. So we had this included. Yeah, so just the last slide to give you an overview. Maybe one more click, so we see the map. So this is from the perspective of a German subthreshold manager. We have taken the information we have gathered and sort of illustrated the map. Where can a manager market to? Where can it market to professional investors only? And where is the scope extended a little bit? Where can it also market to semi-professional investors in the relevant jurisdictions? And as you can see, pretty much straight away, there are some green countries. So where there's this sort of like a simplified regime where German fund managers can access the market also to semi-professionals. Most of the map is either yellow, so professional investors, which is still pretty good. So the UK, for example, Luxembourg, for example. But then there are, as is clearly visible, also a lot of countries which are which are red. So there's no what this essentially means, there is no simplified marketing regime in these countries. And if a German subthreshold manager wanted to market in these countries, the Netherlands, for example, or France, we will get to, they would need to opt in and be basically under the full-fledged AIFMD compliance. And that is definitely something to consider. Yeah, sorry. So this is something to consider that fund managers should take into consideration the scope of their marketing activities.
Thank you very much, Lennart, for that introduction. So that is the map we will try to look a bit closer at in the next few minutes. And as we will see, marketing may not always mean marketing in every country, and by that, red may not always be red in every country or the same red. As we are moving to you, Christophe from Chammas Marcheteau in France, you will tell us a bit about what may still be possible, even though marketing as such is not possible in France. Over to you, Christophe.
Thank you very much, Fabian and Lennart, for this introduction. So I have the pleasure to give you an overview of the marketing regime of EUAF in France. And I would like to start by the definition of marketing, what is meant by marketing. Of course, it starts from the definition of the AIFMD Article 4, under which marketing means an offering or placement at the initiative of the AIFM to investors. So following this definition, the French regulator AMF gave its interpretation of this definition and considers that basically the offering or placement of units of an AIF as being its presentation on the French territory by any means in a view to permit the investor to subscribe in such an AIF. So the important thing is that to note is that, of course, the definition is very large, and any means used to try to encourage an investor to subscribe in AIF may fall under this definition. As to the applicable regime, and as previously mentioned by Lennart, the French marketing regime is quite strict because only fully licensed investment manager are allowed to market their AIF through the marketing passport. It means that sub-threshold AIFM are not allowed to market their shares or units of AIF in France. Of course, we have the possibility to you have the possibility to market your funds through the EuVECA label in France. And just as a matter of information, I checked yesterday on the central database, and it seems that there are 11 German managers who are authorized to market their shares in France. But it is important to note that the French regulation has set out marketing exemptions. So it means that the regulator has defined 8 exemptions under which you will not be considered as being marketed in France on the French territory. The first one, which is quite usual, and is the reverse solicitation, and of course it's a consequence of the definition of marketing, meaning that if the subscription of units of an AIF result from a request of an investors that has not been solicited by the AFMD, then it's you fall under the reverse solicitation, and it is not defined as a marketing activity in France. The other one, which could be also helpful, is the portfolio management agreement exemption. It means that where an asset manager that basically has entered into a portfolio management agreement with a client decide to subscribe in units of an AIF, and providing that such portfolio management agreement authorize the subscription of units of such AIF, then it will not be qualified as a marketing activity, because the IMF considers that basically it's more an investment management decision of the asset manager to invest in the AIF according to the terms of the portfolio management agreement, rather than a marketing activity of the AIF that has been subscribed under this portfolio management agreement. Another exemption which could be also interesting for sub-threshold manager is the fund of fund exemption, meaning that it's the same reasoning. It means that where an asset manager subscribe units of AIF within the framework of the bylaws of the fund that it manage, then we consider that the AIF that has been subscribed by the fund managed by the AIFM, this activity will not be considered as a marketing activity. Again, we see it more like an investment management decision that is taken by the fund of fund manager to invest in AIF, or rather than a marketing activities of this AIF in France. Recently, 2 years ago, we have amend the marketing exemption and add a certain new exemption. And one of the new exemption that has been incorporated within the framework is what we call the pre-marketing exemption. We didn't have any pre-marketing rules or exemptions, in order to be attractive, we have amended the regulation in order to allow management company to do pre-marketing activities, which basically consist for the management company to approach a certain number of investors, which shall not exceed 50, in order to basically gauge their interest for the project of their AIF. Of course, some condition has to be fulfilled. The investor needs to be professional investors or with retail investors that could subscribe for more than 100,000 euro, and this pre-marketing activity can only be done with let's say draft document. You are not allowed, the management company is not allowed to present a final version that could lead to a final subscription of the investors. So it could be useful for asset manager and in particular private equity manager, but you should keep in mind that at the end of the day, the rules, the marketing rules needs to be observed, meaning that you can use this practice to gauge the interest of the investors for your fund, but at the end of the day, the investors could only subscribe in such fund only through the passport regime. So it's not a solution for a sub-threshold manager. The other exemption that I would like to mention are exemption 7 and 8. 7 because once again it's a new one. It allows a management company to participate in meeting and conference in order to present their activities or market trends, provided that the conference are dedicated to professional investors, and there is no specific solicitation for a given fund. Once again, the idea is that investors that could be present at this meeting cannot invoke reverse solicitation. So that's why it is prohibited to solicit for a specific fund during this conference. And the last one that could be helpful is the exemption under which a management company will respond to RFP for a specific project to create an AIF.
Thank you very much, Christophe. For that, we have received a question from the audience, which I believe fits quite well here. So the question is there a possibility to combine the pre-marketing exemption with a reverse solicitation exemption? So if you have a first contact, which is considered pre-marketing, is there then still a room to follow up or to a follow-up by the investor, and that follow-up by the investor or potential investor being seen as a reverse solicitation still?
No, the answer is unfortunately no. You cannot invoke the reverse solicitation following the pre-marketing.
All right. Thank you very much, Christophe. And so we are now moving on and have a look at another jurisdiction, which is the UK. And UK, unlike other countries, has not deleted its private placement regime, but rather still has this in place. So it operates separate from that. But over to you, Chris Dearie.
Thank you very much, Fabian. This tour of European capital cities rather puts me in mind of Eurovision, and for those concerned listeners, I can confirm, in case you were in any doubt, that the UK, despite Brexit, will remain part of Eurovision, so you can continue to laugh at us from afar. Brexit, of course, is dominating the headlines here in the UK. But for the time being, and at least until the 29th of March next year, the UK will remain a full member of the European Union, and all European legislation which has been transposed into UK law will continue to have effect. Indeed, the UK government has confirmed that even in the event of a hard Brexit, which we all hope won't happen, all existing European law will continue in force for a certain period of time. And this confirmation provides helpful certainty, I think, for European fund managers who are marketing or proposing to market in the UK in the future, because it basically provides that the rules, or the existing rules, which regulate the marketing of investment funds in the UK from a European perspective, i.e. the AIFMD and EuVECA, will continue unchanged for at least the next 3 years. So if we move on to the next slide, please. I'm not going to spend a great deal of time discussing the UK rules, you'll be pleased to learn, because actually the rules governing the marketing of alternative investment funds by sub-threshold managers, whether from the European Union or beyond, are relatively straightforward. The UK's approach in implementing the AIFMD has been what we call an intelligent copy-out, and has been with a view to going no further than the directive the AIFMD provides. So there's generally been no what we call gold plating by the UK regulator. So, for example, marketing has been given a fairly restrictive interpretation by the UK regulator, meaning that any offer or placement of units in an AIF is construed to mean the final form documents being passed to investors such that they may be able to consummate the investment in a fund. Anything short of that final form documentation phase will constitute pre-marketing and won't trigger any AIFMD compliance obligations in the UK. In the pre-marketing phase, managers would have to nevertheless comply with the UK's financial promotion regime, which we'll come on to discuss in a moment. But generally, that is relatively easy to navigate. Of course, as Christophe mentioned a moment ago, there is the reverse solicitation exemption, which again is applied fairly sensibly in the UK. Any manager who can demonstrate that there has been a legitimate inquiry from a prospective investor and can document that will generally in the UK be able to rely upon the reverse solicitation exemption. And the FCA, the UK regulator, has indicated that it will tend not to look beyond a written confirmation from an investor that it is investing at its own initiative, unless it's very clear from the factual matrix that the investor has been asked to provide this confirmation simply to get round the directive. So, speaking of sub-threshold managers particularly, as you will be aware, sub-threshold managers are generally outside the scope of the AIFMD, and in the UK are subject to the UK's national private placement rules. Sub-threshold managers in the UK are collectively known as small AIFMs, and we have here the concept of small authorised AIFMs. Those are AIFMs who are authorised by the Financial Conduct Authority, and small registered AIFMs. Those are entities which appear on a register maintained by the FCA, but are not subject to authorisation. The small registered regime is applicable in particular to real estate funds and to EuVECA funds. There is an important distinction to be drawn between small third country AIFMs on the one hand and small EEA AIFMs. I think that the UK is unusual and perhaps unique among the jurisdictions represented on this webinar in having a separate regime for small third country AIFMs, that is to say, sub-threshold AIFMs established outside of the EEA. Small third country AIFMs must register with the FCA. They must comply with the annual reporting obligations for domestic sub-threshold AIFs, which of course is relatively light touch, and they must comply with the financial promotion rules and, where applicable, the PRIPS regulation. And we'll go on to talk about that in a moment or two. Small EEA AIFMs, on the other hand, fly under the radar when it comes to marketing in the UK. There are no equivalent requirements to register with the FCA, and there is no requirement to comply with the annual reporting obligations. Small EEA AIFMs must only comply with the financial promotion rules and, where applicable, the PRIPS regulation. And I think that the logic behind that is that as small EEA AIFMs, i.e. sub-threshold EEA AIFMs, are not governed in general by AIFMD in their own member state, which of course is a member state of the European Union, and we respect the legislative probity of the respective other 27 European jurisdictions. There's no reason for them to be governed by any AIFMD related legislation in the UK. You could of course say the same about small third country AIFMs, but of course Article 42 of the AIFMD doesn't distinguish between sub-threshold and above threshold third country AIFMs. So broadly, other than the reporting requirements and the need to register with the FCA, the requirements for small third country AIFMs and small EE AIFMs is broadly the same, i.e. compliance with the financial promotion regime or the financial promotion restriction and PRIPS, and I'll go on to talk about those now. So the financial promotion restriction in the UK prohibits the making of invitations or inducements to engage in investment activity, such as the acquisition of units in alternative investment funds, either without authorization from the FCA or unless the communication is approved by someone who's authorized by the FCA, or if an exemption applies. And breach of this rule, the financial promotion restriction, can have potentially serious consequences. It may void transactions, it may lead to rights of compensation for investors, and so on. And I've heard it being described in the past as effectively giving investors a free put to get out of funds should they feel that their investment is going the wrong way. There are various exemptions to the financial promotion restriction, and typically small AIFMs can rely on one or more of these exemptions. Typically, they would rely on the exemption relating to investment professionals. I should say at this point that investment professionals for UK financial services, domestic financial services legislation differs from the professional client definition under MiFID, and it's simply a person who carries on regulated activities as part of their ordinary business, and directors and officers and employees of persons who do that are also covered. So generally, in the UK, it's possible to market to these people as well as to certain high net worth persons and certain sophisticated investors, provided the relevant disclaimer language is attached to the document without too much trouble. And I just wanted to pick up one point just on one of the other slides that was shown earlier. I think on the map, it suggested that AIFs and subthreshold AIFs can only be marketed to professional investors in the UK. That's not quite right, in fact. It is possible to market to semi-professional investors in the UK because the financial promotion regime permits marketing to these sorts of people, so to people who may be high net worth individuals and certain sophisticated investors. But that has its own impact because of the PRIPS regulation, which I mentioned a moment ago. The PRIPS regulation is the Packaged Retail Insurance-Based and Investment Product Regulation, which in short requires a key information document to be provided to retail investors who are to whom PRIPS are made available. Now, as I say, the UK permits the marketing of AIFs by small AIFMs to, in inverted commas, retail investors. But that's not retail investors in the ordinary meaning of that term. Retail investors are people who may not necessarily fall within the MiFID qualitative and quantitative tests, but nevertheless fall within the UK's high net worth or sophisticated investor categories. So it's very important, actually, when thinking about marketing to these sorts of people, to ensure that if you are marketing to people who wouldn't fall necessarily within the MiFID professional client test, to make sure that you've done your diligence and have taken steps to prepare the key information document if necessary. I wanted to say just one final word about the EuVECA regime. My understanding is that rather like AIFMD itself, the EuVECA regime has been implemented in a rather patchwork fashion across the European Union. I'm pleased to say that the EuVECA regime has been implemented again in a reasonably straightforward way in the UK, and so far as I'm aware, there are no great problems in European EuVECA managers passporting their funds into the UK. However, a potential hard Brexit, which we talked about earlier, raises certain issues for UK EuVECA managers. As you may be aware, EuVECA passports are only available in respect of funds which are established in the European Union, and clearly in the event of a hard Brexit on the 30th of March next year, the UK would not be a European, or sorry, an EU member state, meaning that a EuVECA manager from the UK hoping to passport or to continue to use its passport in the other EU 27 may face some at least technical legal difficulties. But I'm pleased to tell the European listeners on the call that there's no such issue for non-UK EuVECA managers. The FCA and the UK Treasury have developed what's been called a temporary permission regime, which will permit European EuVECA managers to continue to market in the UK on their pre-Brexit terms and conditions for at least 3 years. So that is one helpful clarification again for the UK Treasury, and we're hoping, of course, that there will be no hard Brexit. But if there is, we're hoping that our friends in Europe will be able to come up with an equivalent regime to allow us to continue to market our funds slightly more widely than the UK.
Thank you very much, Chris. That is very helpful and sheds much light on that. You really have to look specifically at every country, and every country has its own definition of semi-professional, sophisticated investors who may be treated differently from other investors who are pure retail. And that makes it a bit burdensome to do sub-threshold marketing. But if you're not doing a broad marketing over all of the EU, it might still be worth it, given that a EuVECA registration itself also carries a certain burden, and at least takes a little more time than a pure registration. So also, we are very pleased to hear that EuVECA marketing will still be possible after March 30th, and we shall see in the next few months how this evolves over the time. So thank you very much, Chris. And now we are moving on and look at a country which already is inside Europe, but not an EU country at the moment. And this has a totally different regime. Over to you, Dominik.
Yeah, hello everybody. My name is Dominik, and I would like to give you some details on how to market foreign funds in Switzerland. My presentation is subdivided into two areas, or two areas. The reason is that the whole law will change. This summer, the Swiss Parliament has resolved on two new acts, which will actually put the whole financial market system in Switzerland a little bit upside down, most likely from the 1st of January 2020 on. So, in the first part, we will look at the current situation. So the legal situation starting now, or as it is now, until the end of 2019. And in the second part, we will look at how the legal framework will be from the 1st of January 2020 on. At this moment, so the current regime is actually characterized by 4 legal acts. This is a good framework. It's actually easy to understand. We have a Collective Investment Schemes Act. We have 2 ordinances which implement these acts, and we have 1 circular issued by FINMA on the distribution of collective investment schemes. It's most, we will go into the details, but it's everything can actually found in these 4 acts. Now, if we get on by 1 more page, please, we see the system is different from what we have just heard. Switzerland is not a member of the European Union. Switzerland is not a member of the European Economic Area. So the Swiss situation is different from the one in France, and it's different from one in Germany and in the UK. AIFM is not applicable. The UCITS directive is not applicable, and MiFID is not applicable. So we just have to look at the pure Swiss legal system, and the rest doesn't really help us. But what does we look at? We look only at the fund and at the distributing person. No, not yet, please, not yet. You're too fast. So at the fund, and we are looking at the distributing person. We are not looking at the manager. So whether the manager is in Europe or in the European Union or not, and whether the manager is regulated or not, is not relevant for the distribution rules in Switzerland. And to the same extent, it's not relevant whether we are under a threshold or above a threshold. We only look at the fund and at the distributing person. Now, what do these 2 have to satisfy? Now, please, 1 more slide. So when we look first at the fund, the requirements to be satisfied by the fund depend on the target investor. And now we look at 3 lines, and these will actually be the same through the whole presentation. We have 3 different target investors. The easy ones are the regulated qualified investors. These are like financial intermediaries such as banks, insurance companies, administrators, licensed fund management companies. If we distribute funds only to these falls under the national private placement regime, so that nothing has to be satisfied. The fund can be distributed, any fund can be distributed to them. Cayman funds, German funds, French funds, UK funds, anything can be distributed to these regulated qualified investors, and no requirements have to be satisfied. Slightly above are the not regulated qualified investors, so the second line. These are principally high net worth individuals and structures set up for high net worth individuals like trusts, family office, and so on. pension funds, which are always important in the alternative area, and public entities like the government itself, cantons, municipalities, and their entities. If we want to distribute funds to these not regulated qualified investors, the fund has to appoint a representative, a Swiss representative, which is similar to what is foreseen in the AIFM. We need to appoint a paying agent, and the prospectus of the fund needs to have a Swiss annex giving some disclosure information. And at the very end, the non-qualified investors are the retail investors. These are actually all others, so principally everybody who is not a regulated qualified investor, or who is not regulated qualified investor. For those, the distribution of alternative investment funds is not possible. So even by registering the fund or anything, you do not get alternative investment funds to be distributed to retail investors. So this is what has to be satisfied by the fund at this moment. Now, next slide, please. When we look at the person distributing the fund, we again have the three lines. The regulated qualified investors, which are financial intermediaries, also the person distributing such an alternative investment fund does not need to satisfy any requirements. It's the private placement regime, nothing has to be satisfied. So the distributing person does not need a license, does not need to be registered or anything. When the distributor wants to distribute an alternative fund to not regulated qualified investors, what we have seen are principally high net worth individuals, pension funds, and public entities, the distributor, so the person who actually distributes the funds, needs to have a license as a distributor, either by FINMA or an equivalent license by a foreign supervisory authority. So this is possible. This can actually be from Germany. We have distributors from the UK, from France. We can manage that they are allowed to distribute their alternative funds to not regulated qualified investors. But we have to prove that they satisfy these requirements. And again, at the end, the distributor who wants to distribute the alternative investment funds to the non-qualified investors, as I said before, this is not possible. So actually, we do not have to answer the question whether they have to satisfy any requirements. Alternative funds for retail investors is a no-go in Switzerland.
So maybe just shortly, sorry for interrupting, Dominik. Just shortly, for us to understand, the distributor, is that equivalent to the manager, or is that a separate third party doing the marketing for the fund on behalf of the manager?
Yeah, this is a good question. Actually, it can be either or. So if the manager wants to distribute the fund himself, he has to satisfy the requirements which I've just described. If a placement agent is appointed, that means an independent distributor, this placement agent has to satisfy these requirements. What does it mean in practice? If the manager wants to distribute his fund himself, if the manager is not regulated, let's assume he comes from any exotic country where he does not need to be licensed at all and cannot prove any supervisory regime, then he will not achieve this second line. So he is not subject to an equivalent license, and he is not allowed to distribute his fund to non-regulated qualified investor. But he is allowed to distribute his funds to regulated qualified investors, so the first line, because as I said, this is a private placement regime, no rules apply there. So the notion of distributor does not depend on whether the person is the manager or not. It only depends on whether this person is carrying out any distributing activity or not.
Thank you very much, Dominik.
Oh, you're welcome. Okay, then maybe let's go on to the next slide. Okay, so now we get on to what will happen in Switzerland in maybe a year or so. As I said, 2 new acts will actually come into force. And this is the Financial Services Act and the Financial Institutions Act. These two acts have been resolved by Swiss Parliament this summer. We are currently working on the ordinances implementing these two acts. The object of these two acts is actually to bring Swiss financial markets law on an equivalence to MiFID II. Whether this will be achieved or not will be seen. I think many people have their doubts whether this is equivalent, and even if it is, we have some doubts whether the European Commission will grant the equivalence, but this is to be seen. Now, when we just had the one act dealing with everything before, I mean, at this moment, as I said, we had the Collective Investment Schemes Act. In the future, we will have to look at two different regimes. Whatever relates to the fund is still regulated in this Collective Investment Schemes Act, which, however, will be amended. And whatever relates to the offering person or the distributing person will be dealt in the Financial Services Act, in the Financial Institutions Act. And you may have already realized I'm using now the term offering. This is one of the key changes. The term of the distribution is replaced by offering, which in practice will have an effect that the whole understanding is not that broad anymore. So most likely the activities which will fall under the Act, under the Financial Services Act, will be narrowed down, giving some more leeway. How does it look in detail now? And maybe you can go on one more slide, please. Again, we first look at the fund, and in the second step, we look at the offering person. And we again have these three lines. Now, when we look at the fund, as I said, this will continue to be governed by the Collective Investment Schemes Act. When we offer an AF to regulated qualified investors, like, and now this is broadened, financial intermediaries, pension funds, public entities, no requirements will need to be satisfied anymore. So that means no representative, no paying agent, and no amendment to the prospectus. This gives us, in practice, we will see that this gives us a lot of freedom, because principally the pension funds, the high net worth individuals, for which we had to appoint a representative and a paying agent, or have to appoint a paying agent and a representative on the current regime, we will not need to appoint such these two functions anymore, which makes distribution of alternative funds to pension funds principally much cheaper. So we still will have a private placement regime to regulated qualified investors. If the alternative fund is distributed or offered to not regulated qualified investors, and these will only be high net worth individuals and private structures set up for high net worth individuals, there we will still need to have a representative and a paying agent and an amendment to the prospectus. And the third line, if the AIF will be offered to non-qualified investors, we will face the same problem as before. This won't be possible anymore. So alternative funds will not be offerable to retail investors, even in the future. In short, the system remains more or less the same, but we will have an improvement insofar, or let's say it makes it a little bit easier insofar that the distribution or the offering of foreign funds to pension funds and to family offices does not need the paying agent and the representative anymore. Now, when we look at the offerer, that means the person carrying out the activity of offering the fund. Person can be the manager or can be a placement agent or even anything else. We will follow the system which we can also find, the rules of which we can also find in MiFID. We will first ask the question, does this offer carry out a financial service? And there we have principally three times. Does he do any acquisition or disposal of financial instruments? Does he perform portfolio management services or investment advice? If he does not, then the Financial Services Act and the Financial Institutions Act will not apply, with the consequence that he does not have to satisfy any requirements. However, if the offerer does carry out any of these financial services, then yes, Financial Services Act will apply. He needs a license or needs to be registered as a financial services provider, and he has to satisfy the duties of care set forth in the Financial Services Act, which are more or less comparable to what we know from MiFID. So that's an overview of what's the case now in Switzerland, what applies at this moment in Switzerland, and what will be the situation in Switzerland in the future. We have, of course, these two exemptions of the pre-marketing and the exemption of the reverse solicitation. Both concepts and exemptions will continue to be possible. In general, we can say that both concepts are very narrow in Switzerland. Under the current regime, the reverse solicitation is not defined in any act or ordinance, but the concept as it is understood by FINMA is more or less the same as we know it from MiFID. So that means that we only have a reverse solicitation. It's the very first contact is made by the investor. And if the first contact is made by the manager or offer or by any party of the fund, then the private placement regime, the reverse solicitation exemption does not apply. When it comes to pre-marketing, it's more or less the same. Pre-marketing really means that the details of the fund are not known yet. So it's not just sufficient not to provide the name of the product yet or to only indicate a range of the fees. We really need to have not an exact knowledge of the fund in order to for the pre-marketing exemption to apply. And this will more or less continue in this sense under the new regime. Well, that's from the Swiss point of view.
Thank you very much, Dominik. That was very interesting. And I think we had a very good impression what it looks like to market with or without a passport. And in particular, thank you very much for highlighting that things will change in the future in Switzerland. I think we can still take the time to answer a very last question, which is the question, under the current regime, if you're marketing to high net worth individuals, so to non-regulated but sophisticated investors, is there a minimum investment amount or something like that in Switzerland as well?
Yeah, thank you very much. I think that's a good question. To give a short answer, no, there is not such a requirement. The high net worth individual needs, the offering person needs to have the evidence that the high net worth individual indeed is a high net worth individual. What does it mean? 500,000 Swiss francs liquid assets plus knowledge, financial knowledge, or at least 5 million liquid assets. And then the person qualified as a high net worth individual. It's irrelevant of how much money the person invests, whether it's a lot or not, but he has to prove this requirement. Under the new regime, the situation will be more or less the same, but the 5 million threshold will go down to 2 million. But again, there is no minimum investment to be made in order to qualify as a high net worth individual.
Thank you very much, Dominik. I think we have run already out of time, but everyone from the speakers is happy to answer directly to any further questions there are. And I say again, thank you very much to you, Chris, Christophe, and Dominik for participating in this effort, and naturally also to Lennart. So thank you very much. I think it was very interesting, and speak to you at another day. Bye-bye.